SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor from Law Center 2, Faculty of Law, University of Delhi. We will continue now from the previous lecture where we left. This is lecture number 18, where we will continue to discuss and talk about seafarers' rights and responsibilities. We are well aware of the problems that seafarers face or used to face as far as their basic human rights are concerned, as far as their basic fundamental rights are concerned, which may be related to contract between employer and employee, which may be related to their minimum wages, minimum working hours, collective bargaining, the health conditions, the staying requirements not getting fulfilled, the problems pertaining to repatriation, the problem pertaining to their working conditions of any nature which is present as far as seafaring is concerned. We have seen through the previous lecture that a number of problems were being faced by these seafarers, and in order to mitigate these problems, in order to resolve such problems, in order to ensure that there is no forced labor, that there is human rights compliance as far as seafarers are concerned, we see that an updated law, international law has come into being, which is known as Maritime Labour Convention 2006, which consolidates almost all the earlier laws and makes rules and regulations pertaining to the rights and responsibilities of the seafarers. It imposes obligations upon the flag states to comply with the international rules pertaining to the rights of the seafarers. The seafarers are certainly responsible to be well trained, obtain a certificate of a particular training. At the same time, it is the duty of the flag state, the port state, to ensure compliance with respect to implementation of human rights of the seafarers. In the last lecture, we discussed about, or we touched upon, different articles or provisions of the Maritime Labour Convention, which imposes significant duty upon the flag state or the port state. We also saw mentioning of fundamental rights of the flag states, fundamental duties of the flag state and fundamental rights, corresponding rights of the seafarers. Now, these got enumerated specifically and identified specifically in two parts, part A and part B, under 5 different titles, where the first 4 titles specifically identifies in detail the different rights that exist as far as the seafarers are concerned and different duties of the member states as far as the seafarers are concerned. So, therefore, we started by discussing title 1 in the last class and then title 2, wherein we talked about minimum working hours, maximum working hours and minimum rest period. We also talked about the terms of employment as far as contractual agreement between the employer and employee is concerned. We also talked about the fundamental rights with respect to minimum age requirement is concerned, certain conditions of work with respect to medical and health is concerned. So, certain aspects of the same have been already discussed. Now, there are other certain aspects, there are certain specific rules and regulations that must be complied in a mandatory or certain rules and regulations in a non-mandatory form to be applicable upon the flag state as far as MLC normativity is concerned. Now, let us start with title 3, which talks about accommodation, recreational facilities, food and catering. Regulation 3.1 talks about accommodation and recreational facilities. Purpose is to ensure that seafarers have decent accommodation and recreational facilities on board. Each member shall ensure that ships that fly its flag provide and maintain decent accommodations and recreational facilities for seafarers working or living on board, or both, consistent with promoting the seafarers' health and well-being. The requirements in the code implementing this regulation, which relate to ship construction and equipment, apply only to ships constructed on or after the date when this convention comes into force for the member concerned. For ships constructed before that date, the requirements relating to ship construction and equipment that are set out in Accommodation of Crews Convention 1949 and the Accommodation of Crews Supplementary Provisions Convention 1970 shall continue to apply to the extent that they were applicable prior to that date under the law or practice of the member concerned. A ship shall be deemed to have been constructed on the date when its keel is laid or when it is at a similar stage of construction, and from that date onwards it will be identified that whether the ship will be coming under the domain of MLC or will also be coming under the domain of Accommodation of Crews Convention or Accommodation of Crews Convention 1970 or 49. Further, unless expressly provided otherwise, any requirement under an amendment to the code relating to the provision of seafarer accommodation and recreational facilities shall apply only to ships constructed on or after the amendment takes effect for the member concerned. Standard A 3.1 talks about accommodation and recreational facilities. Now, as we have already identified that there is a standard A and then post standard A we have guideline B. So, part A denotes or the standard denotes mandatory requirements, guidelines B are non-mandatory requirements as far as the flag states are concerned. So, standard A 3.1 deals with accommodation and recreational facilities and says that each member shall adopt laws and regulations requiring that ships that fly its flag meet minimum standards to ensure that any accommodation for seafarers working or living on board or both is safe, decent and in accordance with the relevant provisions of this standard and are inspected to ensure initial and ongoing compliance with those standards. Secondly, in developing and applying the laws and regulations to implement this standard, the competent authority, after consulting the ship owners and seafarers organizations concerned, shall take into account Regulation 4.3 and the associated code provisions on health and safety protection and accident prevention in light of the specific needs of seafarers that both live and work on board ship, and give due consideration to the guidance contained in Part B of this code. The inspections required under Regulation 514 shall be carried out when a ship is registered or re-registered. Now, when we talk about Regulation 514, we mean to point out to Title 5, wherein it is incumbent or it is the duty of the flag state to enforce or to implement the rules and regulations mentioned under the mandatory standards of Maritime Labour Convention 2006. So, and as also to carry out it when the seafarer accommodation on a ship has been substantially altered. The competent authority shall pay particular attention to ensuring implementation of the requirements of this convention relating to the size of rooms and other accommodation spaces, heating and ventilation, noise and vibration and other ambient factors, sanitary facilities, lighting and hospital accommodation. So, a comfortable environment must be provided as far as the seafarer is concerned. Merely providing resting hours will not suffice, but also making conducive environment or creating conducive scenario or environment for the seafarer is also necessary. If it is a cold condition, then proper heating must be there, a proper ventilation must be provided. If it is a hot condition, weather condition, proper temperature must suitable for a rest, bodily rest condition must be provided. A hospital accommodation must also be provided. If the person gets sick on board, then proper care must be taken, proper services must be provided as far as the sickness or illness is concerned. The competent authority of each member shall require that ships that fly its flag meet the minimum standards for onboard accommodation and recreational facilities that are set out in paragraph 6 to 17 of this standard. Now, look at these paragraphs from 6 to 17. With respect to general requirements for accommodation, there shall be adequate headroom in all seafarer accommodation. When we say headroom, that means that the seafarer must be able to adjust the body in the given provided space. The minimum permitted headroom in all seafarer accommodation where full and free movement is necessary shall be not less than 203 centimeters. The competent authority may permit some limited reduction in headroom in any space or part of any space in such accommodation where it is satisfied that such reduction is reasonable and will not result in discomfort to seafarers. The accommodation shall be adequately insulated. In ships other than passenger ships as defined in regulation 2E and F of the International Convention for the Safety of Life at Sea 1974 as amended SOLAS Convention, sleeping rooms shall be situated above the load line amidships or aft. So, the load line is the line which represents the loading of the cargoes. Once the cargoes are loaded, above the load line you have the freeboard or the free area. Now, in this free area, freeboard area, the accommodation can be adjusted as far as the SOLAS convention is concerned. So, load line amidships or aft, that is the backside of the ship, except that in exceptional cases where the size, type or intended service of the ship renders any other location impracticable, sleeping rooms may be located in the forepart of the ship, but in no case forward of the collision bulkhead. Further, in passenger ships and in special ships constructed in compliance with the IMO Code of Safety for Special Purpose Ships 1983 and subsequent versions hereinafter called Special Purpose Ships, the competent authority may, on condition that satisfactory arrangements are made for lighting and ventilation, permit the location of sleeping rooms below the load line, but in no case shall they be located immediately beneath working alleyways. There shall be no direct openings into sleeping rooms from cargo and machinery spaces or from galleys, storerooms, drawing rooms or communal sanitary areas. That part of bulkhead separating such places from sleeping rooms and external bulkheads shall be efficiently constructed of steel or other approved substance and be watertight and gas tight. The materials used to construct internal bulkheads, paneling and sheeting, floors and joinings shall be suitable for the purpose and conducive to ensuring a healthy environment. Proper lighting and sufficient drainage shall be provided, and accommodation and recreational and catering facilities shall meet the requirements in regulation 4.3 and the related provisions in the code on health and safety protection and accident prevention with respect to preventing the risk of exposure to hazardous levels of noise and vibration and other ambient factors and chemicals on board ships, and to provide an acceptable occupational and on-board living environment for seafarers. Now, under 7 point, with respect to requirements for ventilation and heating, sleeping rooms and mess rooms shall be adequately ventilated in order to avoid any kind of suffocation. Further, ships except those regularly engaged in trade where temperate climate conditions do not require this shall be equipped with air conditioning for seafarer accommodation for any separate radio room and for any centralized machinery control room. All sanitary spaces shall have ventilation to the open air independently of any other part of the accommodation, and adequate heat through an appropriate heating system shall be provided, except in ships exclusively on voyages in tropical climates. With respect to requirements for lighting, subject to such special arrangements as may be permitted in passenger ships, Sleeping rooms and mess rooms shall be lit by natural light and provided with adequate artificial light. With respect to requirements for hospital accommodation, ships carrying 15 or more seafarers and engaged in a voyage of more than 3 days duration shall provide separate hospital accommodation to be used exclusively for medical purposes. The competent authority may relax this requirement for ships engaged in coastal trade. In approving on-board hospital accommodation, the competent authority shall ensure that the accommodation will in all weathers be easy of access, provide comfortable housing for the occupants, and be conducive to their receiving prompt and proper attention. Appropriately situated and furnished laundry facilities shall be available. All ships shall have a space or spaces on open deck to which the seafarers can have access when off duty, which are of adequate area having regard to the size of the ship and the number of seafarers on board. Further, all ships shall be provided with separate offices or a common ship's office for use by deck and engine departments. Ships of less than 3000 gross tonnage may be exempted by the competent authority from this requirement after consultation with the ship owners and seafarers organizations concerned. Ships regularly trading to mosquito infested ports shall be fitted with appropriate devices as required by competent authority. Further, appropriate seafarers recreational facilities, amenities and services as adapted to meet the special needs of seafarers who must live and work on ships shall be provided on board for the benefit of all seafarers, taking into account regulation 4.3 and the associated code provisions on health and safety protection and accident prevention. Further, the competent authority shall require frequent inspections to be carried out on board ships by or under the authority of the master to ensure that seafarer accommodation is clean, decently habitable and maintained in a good state of repair. The results of each such inspection shall be recorded and be available for review. In the case of ships where there is need to take account without discrimination of the interests of seafarers having differing and distinctive religious or social practices, the competent authority may, after consultation with the ship owners and seafarers organization concerned, permit fairly applied variations in respect of this standard on condition that such variations do not result in overall facilities less favorable than those which would result from the application of this standard. So, religious practices can also be given preferences, can also be adjusted. However, at the same time the primary rights should be first ensured. They must not be compromised in whatsoever manner. If any space is available after recognition and realization of all the basic human rights and fundamental rights, then religious rights or recreational rights pertaining to religious activities can also be adjusted. Further, any exemptions with respect to the requirements of this standard may be made only where they are expressly permitted in this standard and only for particular circumstances in which such exemptions can be clearly justified on strong grounds and subject to protecting the seafarers' health and safety. Now, we have the guidelines. The above points or the above norms were standards mentioned under part A, which are to be complied by the member parties. Now, we have guidelines with respect to accommodation and recreational facilities, which are non-mandatory as far as the member states are concerned. So, guideline B 3.1.1 talks about design and construction in order to accommodate the accommodation part or in order to provide guideline for the accommodation and recreational facilities. External bulkheads of sleeping rooms and mess rooms should be adequately insulated. All machinery casings and all boundary bulkheads of galleys and other spaces in which heat is produced should be adequately insulated where there is a possibility of resulting heat effects in adjoining accommodation or passageways. Measures should also be taken to provide protection from heat effects of steam or hot water service pipes or both. Sleeping rooms, mess rooms, recreation rooms and alleyways in the accommodation space should be adequately insulated to prevent condensation or overheating. So, when we talk about accommodation, accommodation does not only mean that the person must have a place to sleep. Yes, a person must have a place to sleep, that must be adequately positioned and must have adequate space as far as movement of the person is concerned. It must also be accompanied with proper sanitary places, it must also be accompanied with places where the person can move, and also attached with the places where there are recreational activities. So, resting period does not mean only having a bed and a insulated room or isolated place to rest, but other necessary requirements are also to be complied in order to maintain not only the physical being of the person, but also to maintain the mental being of the person. So, it further says that the bulkhead surfaces and deckheads should be of material with a surface easily kept clean. No form of construction likely to harbor vermin should be used. The bulkhead surfaces and deckheads in sleeping rooms and mess rooms should be capable of being easily kept clean and light in color with a durable non-toxic finish. The decks in all seafarer accommodation should be of approved material and construction and should provide a non-slip surface impervious to damp and easily kept clean, so that any kind of accident or similar kind of activity can be avoided. Where the floorings are made of composite materials, the joints with the sides should be profiled to avoid crevices. Now, guideline B 3.1.2 talks about ventilation, which is also an important aspect as far as accommodation is concerned. It says that the system of ventilation for sleeping rooms and mess rooms should be controlled so as to maintain the air in a satisfactory condition and to ensure a sufficiency of air movement in all conditions of weather and climate. Air conditioning systems, whether of a centralized or individual unit type, should be designed to maintain the air at a satisfactory temperature and relative humidity as compared to outside air conditions, ensure a sufficiency of air changes in all air conditioned spaces, take account of the particular characteristics of operations at sea and not produce excessive noises or vibrations, and facilitate easy cleaning and disinfection to prevent or control the spread of disease. Power for the operation of the air conditioning and other aids to ventilation required by the preceding paragraphs of this guideline should be available at all times when seafarers are living or working on board and conditions so require. However, this power need not be provided from an emergency source. Guideline 3.1.3 talks about heating. The system of heating the seafarer accommodation should be in operation at all times when seafarers are living or working on board and conditions require its use. In all ships in which a heating system is required, the heating should be by means of hot water, warm air, electricity, steam or equivalent. However, within the accommodation area, steam should not be used as a medium for heat transmission. The heating system should be capable of maintaining the temperature in seafarer accommodation at a satisfactory level under normal conditions of weather and climate likely to be met within the trade in which the ship is engaged. The competent authority should prescribe this standard to be provided. Radiators and other heating apparatus should be placed and where necessary shielded so as to avoid risk of fire or danger or discomfort to the occupants. Guideline 3.1.4 talks about lighting. In all ships, electric light should be provided in the seafarer accommodation. If there are not two independent sources of electricity for lighting, additional lighting should be provided by properly constructed lamps or lighting apparatus for emergency use. In sleeping rooms, an electric reading lamp should be installed at the head of each berth. Suitable standards of natural and artificial lighting should be fixed by the competent authority. So, we see through these guidelines that even the tiniest and smallest requirement of the seafarer has been taken care of, and if this is implemented in true spirit and word, we can see that a better and harmonious rule pertaining to Maritime Labour Convention is implemented. The rights, the exact rights or the appropriate fair right of the seafarer can be seen to be implemented if these tiny details are also implemented while a ship construction takes place. So, if you look at guidelines pertaining to the mess room also, you will see that B31.6 says that mess room facilities may be either common or separate. The decision in this respect should be taken after consultation with seafarers and shipowners representatives and subject to the approval of the competent authority. Account should be taken of factors such as the size of the ship and the distinctive cultural, religious and social needs of the seafarers. Where separate mess room facilities are to be provided to seafarers, then separate mess rooms should be provided for master and officers and petty officers and other seafarers. On ships other than passenger ships, the floor area of mess rooms for seafarers should be not less than 1.5 square meters per person of the planned seating capacity. In all ships, mess rooms should be equipped with tables and appropriate seats, fixed or movable, sufficient to accommodate the greatest number of seafarers likely to use them at any one time. There should be available at all times when seafarers are on board a refrigerator which should be conveniently situated and of sufficient capacity for the number of persons using the mess room or mess rooms, facilities for hot beverages and cool water facilities. Guidelines B 3.1.7 talks about sanitary accommodation. Wash basins and tub baths should be of adequate size and constructed of approved material with a smooth surface, not liable to crack, flake or corrode. All toilets should be of an approved pattern and provided with an ample flush of water or with some other suitable flushing means, such as air, which are available at all times and independently controllable. Sanitary accommodation intended for the use of more than one person should comply with the following, that is, floor should be of approved durable material, impervious to damp and should be properly drained. Bulkheads should be of steel and other approved material and should be watertight up to at least 23 centimeters above the level of the deck. Further, the accommodation should be sufficiently lit, heated and ventilated. Toilets should be situated convenient to but separate from sleeping rooms and washrooms, without direct access from the sleeping rooms or from a passage between sleeping rooms and toilets to which there is no other access. This requirement does not apply where a toilet is located in a compartment between two sleeping rooms having a total of not more than 4 seafarers, and where there is more than one toilet in a compartment, they should be sufficiently screened to ensure privacy. Guideline 3.1.8 talks about hospital accommodation, which is also a necessary requirement in case if anyone is injured or falls sick or is facing any type of illness. Hospital accommodation, or if any person is facing any communicable disease, a separate isolation room is required. Proper medical facilities should be available in that particular room, and therefore hospital accommodation is again a very basic fundamental right that must be provided. However, it is a guideline mentioned under 3.1.8, and it says that the hospital accommodation should be designed so as to facilitate consultation and the giving of medical first aid and to help prevent the spread of infectious diseases. The arrangement of the entrance, berths, lighting, ventilation, heating and water supply should be designed to ensure the comfort and facilitate the treatment of the occupants. The number of hospital berths required should be prescribed by the competent authority. Sanitary accommodation should be provided for the exclusive use of the occupants of the hospital accommodation, either as part of the accommodation or in close proximity thereto. Such sanitary accommodation should comprise a minimum of one toilet, one wash basin and one tub or shower. Guideline B 3.1.11 talks about recreational facilities, mail and ship visit arrangements. Recreational facilities and services should be reviewed frequently to ensure that they are appropriate in the light of changes in the needs of seafarers resulting from technical, operational and other developments in the shipping industry. Furnishings for recreational facilities should as a minimum include a bookcase and facilities for reading, writing and where practicable games. In connection with the planning of recreation facilities, the competent authority should give consideration to the provision of a canteen. Consideration should also be given to including the following facilities at no cost to the seafarer where practicable: a smoking room, television viewing and the reception of radio broadcasts, showing of films, the stock of which should be adequate for the duration of the voyage and where necessary changed at reasonable intervals. Sports equipment including exercise equipment, table games and deck games, all of which will add to the mental health of the seafarer. Where possible, facilities for swimming, a library containing vocational and other books, the stock of which should be adequate for the duration of the voyage and changed at reasonable intervals. Facilities for recreational handicrafts, electronic equipment such as radio, television, video recorders, DVD, CD player, personal computer and software and cassette recorder player. Where appropriate, the provision of bars on board for seafarers unless these are contrary to national, religious or social customs, and reasonable access to ship to shore telephone communications and email and internet facilities were available, with any charges for the use of these services being reasonable in amount. Every effort should be given to ensuring that the forwarding of seafarers' mail is as reliable and expeditious as possible. Efforts should also be considered for avoiding seafarers being required to pay additional postage when mail has to be readdressed owing to circumstances beyond their control. Measures should be considered to ensure, subject to any applicable national or international laws or regulations, that whenever possible and reasonable, seafarers are expeditiously granted permission to have their partners, relatives and friends as visitors on board their ship when in port. Such measures should meet any concerns for security clearances. Guideline B 3.1.12 talks about prevention of noise and vibration. Accommodation and recreational and catering facilities should be located as far as practicable from the engines, steering gear rooms, deck winches, ventilation, heating and air conditioning equipment and other noisy machinery and apparatus. Acoustic insulation or other appropriate sound absorbing materials should be used in the construction and finishing of bulkheads, deckheads and decks within the sound producing spaces, as well as self-closing noise isolating doors for machinery spaces. Engine rooms and other machinery spaces should be provided wherever practicable, with soundproof centralized control rooms for engine room personnel. Working spaces such as the machine shop should be insulated as far as practicable from the general engine room noise, and measures should be taken to reduce noise in the operation of the machinery. The limits for noise levels for working and living spaces should be in conformity with the ILO international guidelines on exposure levels, including those in the ILO Code of Practice entitled Ambient Factors in the Workplace 2001, and where applicable, the specific protection recommended by the International Maritime Organization, and with any subsequent amending and supplementary instruments for acceptable noise levels on board ships. A copy of the applicable instruments in English or the working language of the ship should be carried on board and should be accessible to seafarers. No accommodation or recreational or catering facilities should be exposed to excessive vibration. Now, regulation 3.2 talks about food and catering. 3.1 had talked about accommodation and recreational facilities. In 3.2 we will talk about food and catering, that how proper healthy and safe and sound food is served and available for the seafarers. The purpose is to ensure that seafarers have access to good quality food and drinking water provided under regulated hygienic conditions. Each member shall ensure that ships that fly its flag carry on board and serve food and drinking water of appropriate quality, nutritional value and quantity that adequately covers the requirements of the ship and takes into account the differing cultural and religious backgrounds. Seafarers on board a ship shall be provided with food free of charge during the period of engagement. Seafarers employed as ship's cooks with responsibility for food preparation must be trained and qualified for their position on board ship. Standard A 3.2. In order to fulfill the above mentioned purpose, the Standard A mentions specific guidelines in order to fulfill the purpose mentioned above. Each member shall adopt laws and regulations or other measures to provide minimum standards for the quantity and quality of food and drinking water, and for the catering standards that apply to meals provided to seafarers on ships that fly its flag, and shall undertake educational activities to promote awareness and implementation of the standards referred to in this paragraph. Each member shall ensure that ships that fly its flag meet the following minimum standards: food and drinking water supplies, having regard to the number of seafarers on board, their religious requirements and cultural practices. Further, the organization and equipment of the catering department shall be such as to permit the provision of the seafarers of adequate, varied and nutritious meals prepared and served in hygienic conditions. Catering staff shall be properly trained and instructed for their position. Ship owners shall ensure that seafarers who are engaged in ship's cooks are trained, qualified and found competent for the position in accordance with requirements set out in the laws and regulations of the member concerned. Further, on ships operating with a prescribed manning of less than 10, which by virtue of the size of the crew or the trading pattern may not be required by the competent authority to carry a fully qualified cook, anyone processing food in the galley shall be trained or instructed in areas including food and personal hygiene, as well as handling and storage of food on board ships. Now, this will be about food and catering as far as the standard is concerned. As far as the guidelines are concerned, the guidelines talk about inspection, education, research and publication. The competent authority should, in cooperation with other relevant agencies in the organization, collect up-to-date information on nutrition and on methods of purchasing, storing, preserving, cooking and serving food with a special reference to the requirements of catering on board a ship. This information should be made available free of charge or at reasonable cost to manufacturers of and traders in ships, food supplies and equipment, masters, stewards and cooks, and to ship owners and seafarers organizations concerned. Appropriate forms of publicity such as manuals, brochures, posters, charts or advertisements in trade journals should be used for this purpose. Now, certain powers are there, that certain obligations are also mentioned under this guideline with respect to the competent authority of the nationals. Now, in Title 3 we talked about food and hygiene conditions, accommodation and recreational facilities. Another important area with respect to maintenance of human rights standards of the seafarers is given under Title 4, which talks about health protection, medical care, welfare and social security protection, which is also a very basic right that exists as far as any human is concerned. So, for seafarers also specially designed standards and regulations are mentioned under Title 4, which ensures or which tries to ensure through Title 5 the compliance of social security, the compliance of medical care, the compliance of health protection. Now, what is the standard and what is the regulation and what is the purpose and guidelines mentioned under Title 4? Let us start with it. The regulation 4.1 talks about medical care on board ship and shore. Purpose is to protect the health of seafarers and ensure their prompt access to medical care on board ship and ashore. Each member shall ensure that all seafarers on ships that fly its flag are covered by adequate measures for the protection of their health and that they have access to prompt and adequate medical care whilst working on board. The protection and care under para 1 of this regulation shall in principle be provided at no cost to the seafarers. Each member shall ensure that seafarers on board ships in its territory who are in need of immediate medical care are given access to members' medical facilities on shore. The requirements for on-board health protection and medical care set out in the code include standards for measures aimed at providing seafarers with health protection and medical care as comparable as possible to that which is generally available to workers ashore. Standard A 4.1 talks about medical care on board ship and ashore. Each member shall ensure that measures providing for health protection and medical care, including essential dental care for seafarers working on board a ship that flies its flag, are adopted, which ensure the application to seafarers of any general provisions on occupational health protection and medical care relevant to their duties, as well as of special provisions specific to work on board ship. It must also ensure that seafarers are given health protection and medical care as comparable as possible to that which is generally available to workers ashore, including prompt access to the necessary medicines, medical equipment and facilities for diagnosis and treatment and to medical information and expertise. Give seafarers the right to visit a qualified medical doctor or dentist without delay in ports of call where practicable. So, if the ship is passing through particular certain ports of call and if a particular seafarer is not well, is sick and requires medical attention immediately, in that particular scenario, it is incumbent upon the member states to allow that particular seafarer on any particular port of call to get checked and treated by medical practitioner or dentist. It must also ensure, to the extent consistent with the members' national law and practice, medical care and health protection services while a seafarer is on board ship or landed in a foreign port are provided free of charge to seafarers, and are not limited to treatment of sick or injured seafarers, but include measures of a preventive character such as health promotion and health education programs. The competent authority shall adopt a standard medical report form for use by the ship's masters and relevant onshore and onboard medical personnel. The form, when completed, and its contents shall be kept confidential and shall only be used to facilitate the treatment of seafarers. Each member shall adopt laws and regulations establishing requirements for onboard hospital and medical care facilities and equipment and training on ships that fly its flag. National laws and regulations shall as a minimum provide for the following requirements. All ships carry a medicine chest, medical equipment and a medical guide, the specifics of which shall be prescribed and subject to regular inspection by the competent authority. So, if there is a medical guide available in case of emergency situation, if the doctor is not available, if a person is of little knowledge about the medical activities, then the person would be in a position to address the problem of a particular person who is suffering from some type of illness or some kind of sickness. In that particular situation, we can ensure that such basic human rights gets assured by the implementation in the domestic legal system. Further, we see that the national requirement shall also take into account the type of ship, the number of persons on board and the nature, destination and duration of voyages, and relevant national and international recommended medical standards. Further, it is upon the national laws and regulations to provide minimum requirements with respect to the ships that are carrying 100 or more persons and ordinarily engaged on international voyages of more than 3 days duration. If the ship is traveling for less than 3 days, we have already discussed that it will be exempted from the requirement. Also, if the ship is carrying people less than 15 persons, then also the ship gets exempted. But if the ship is carrying 100 or more than 100 persons and is traveling for more than 3 days, then the member states or the national rules must call for the duration, must call for certain qualified medical doctor who is responsible for providing medical care. National laws or regulations shall also specify which other ships shall be required to carry a medical doctor, taking into account inter alia such factors as the duration, nature and conditions of the voyage and the number of seafarers on board. Further, the nationals or the member states, we can say, are required to allow the ships which do not carry a medical doctor shall be required to have either at least one seafarer on board who is in charge of medical care and administering medicine as part of their regular duties, or at least one seafarer on board competent to provide medical first aid. Persons in charge of medical care on board who are not medical doctors shall have satisfactorily completed training in medical care that meets the requirements of the International Convention on Standards of Training, Certification in Watchkeeping for Seafarers 1978. Seafarers designated to provide medical first aid shall have satisfactorily completed training in medical first aid that meets the requirements of STCW. National laws or regulations shall specify the level of approved training required, taking into account inter alia such factors as the duration, nature and conditions of the voyage and the number of seafarers on board. And the competent authority shall ensure by a pre-arranged system that medical advice by radio or satellite communication to ships at sea, including specialist advice, is available 24 hours a day. Medical advice, including the onward transmission of medical messages by radio or satellite communication between a ship and those ashore giving the advice, shall be available free of charge to all ships irrespective of the flag that they fly. Guideline B 4.1 talks about medical care on board ship and ashore. Guideline B 4.1.1 provides for provision of medical care. When determining the level of medical training to be provided on board ships that are not required to carry a medical doctor, the competent authority should require that ships which ordinarily are capable of reaching qualified medical care and medical facilities within 8 hours should have at least one designated seafarer with the approved medical first aid training required by STCW, which will enable such persons to take immediate effective action in case of accidents or illness likely to occur on board a ship, and to make use of medical advice by radio or satellite communication. There are further guidelines with respect to medical care on board a ship and ashore, which are non-mandatory type of requirements as far as the member states are concerned. There are other guidelines with respect to medical assistance to other ships and international cooperation, where each member should give due consideration to participating in international cooperation in the area of assistance, programs and research in health protection and medical care. Such cooperation might cover developing and coordinating search and rescue efforts and arranging prompt medical help and evacuation at sea for the seriously ill or injured on board a ship through such means as periodic ship position reporting systems, rescue coordination centers and emergency helicopter services in conformity with the International Convention on Maritime Search and Rescue 1979 as amended, and the International Aeronautical and Maritime Search and Rescue IAMSAR manual, making optimum use of all ships carrying a doctor and stationing ships at sea which can provide hospital and rescue facilities, compiling and maintaining an international list of doctors and medical care facilities available worldwide to provide emergency medical care to seafarers, landing seafarers ashore for emergency treatment, and similar other guidelines have been mentioned in this particular part, wherein the guidelines, the member states may comply. With the passage of time also, we see these guidelines get implemented slowly as the nation or the member state comes to that particular stature. Now, further standard A 4.2.1 talks about ship owners liability, where the ship owner is responsible with respect to the rights of the seafarer. What are the different liability, what is the different liability regime as far as the rights of the ship seafarers are concerned. So, we see that each member shall adopt laws and regulations requiring that ship owners of ships that fly its flag are responsible for health protection and medical care of all seafarers working on board the ships in accordance with the following minimum standards. Ship owners shall be liable to bear the costs for seafarers working on their ships in respect of sickness and injury of the seafarers occurring between the date of commencing duty and the date upon which they are deemed duly repatriated, or arising from their employment between those dates. Further, ship owners shall provide financial security to assure compensation in the event of the death or long-term disability of the seafarers due to an occupational injury, illness or hazard, as set out in national law, the Seafarers Employment Agreement or Collective Agreement. Now, this has been mentioned largely because the seafarer is involved in the duty of the ship owner, and therefore, it is then upon the ship owner, or it is the liability of the ship owner to ensure that proper financial security is provided to the seafarer, as the act was committed in the course of employment. And if the act falls within the domain of in the course of employment, ship owner certainly will be responsible as an employer. Further, ship owners shall be liable to defray the expense of medical care, including medical treatment and the supply of the necessary medicines and therapeutic appliances and board and lodging away from home until the sick or injured seafarer has recovered, or until the sickness or incapacity has been declared of a permanent character. And ship owners shall be liable to pay the cost of burial expenses in the case of death occurring on board or ashore during the period of engagement. National laws and regulations may limit the liability of the ship owner to defray the expense of medical care and board and lodging to a period which shall not be less than 16 weeks from the day of the injury or the commencement of the sickness. Where the sickness or injury results in incapacity for work, the ship owner shall be liable to pay full wages as long as the sick or injured seafarer remain on board, or until the seafarers have been repatriated in accordance with this convention, and to pay wages in whole or in part as prescribed by national laws or regulations, or as provided for in collective agreements from the time when the seafarers are repatriated or landed until their recovery, or if earlier, until they are entitled to cash benefits under the legislation of the member concerned. National laws and regulations may limit the liability of the ship owner to pay wages in whole or in part in respect of a seafarer no longer on board to a period which shall not be less than 16 weeks from the day of the injury or the commencement of the sickness. National laws and regulations may exclude the ship owner from liability in respect of injury incurred otherwise than in the service of the ship, injury or sickness due to the willful misconduct of the sick, injured or deceased seafarer, and sickness or infirmity intentionally concealed when the engagement is entered into. National laws and regulations may exempt the ship owner from liability to defray the expense of medical care and board and lodging and burial expenses insofar as such liability is assumed by the public authorities. So, sometimes the government of a particular state also assumes certain types of liabilities with respect to seafarers, then in such situation the ship owner may be exempted. Further, ship owners or their representatives shall take measures for safeguarding property left on board by sick, injured or deceased seafarer and for returning it to them or to their next of kin. National laws and regulations shall provide that the system of financial security to assure compensation as provided by para 1b of this standard of contractual claims as defined in standard A 4.2.2 meet the following minimum requirements. The contractual compensation where set out in the seafarer's employment agreement and without prejudice to subparagraph C of this subparagraph shall be paid in full and without delay. There shall be no pressure to accept a payment less than the contractual amount. Where the nature of the long-term disability of a seafarer makes it difficult to assess the full compensation to which the seafarer may be entitled, an interim payment or payment shall be made to the seafarer so as to avoid undue hardship. In accordance with regulation 4.2 para 2, the seafarer shall receive payment without prejudice to other legal rights, but such payment may be offset by the ship owner against any damages resulting from any other claim made by the seafarer against the ship owner and arising from the same incident, and the claim for contractual compensation may be brought directly by the seafarer concerned or their next of kin or a representative of the seafarer or designated beneficiary. Now, standard 4.2 para 2 talks about treatment of contractual terms. For the purpose of standard A 4.2 para 1 para 8 and the present standard, the term contractual claim means any claim which relates to death or long term disability of seafarers due to an occupational injury, illness or hazard as set out in national law, the seafarers employment agreement or collective agreement. The system of financial security as provided for in standard A 4.2 para 1b may be in the form of social security scheme or insurance or fund or other similar arrangements. Its form shall be determined by the member after consultation with the ship owners and seafarers organizations. National laws and regulations shall ensure that effective arrangements are in place to receive, deal with and impartially settle contractual claims relating to compensation referred to in standard A 4.2 para 1 para 8 through expeditious and fair procedures. Now, there are certain guidelines also with respect to ship owners liability, the sum of which can be the payment of full wages as required in the standard A. Then national laws and regulations may provide that a ship owner shall cease to be liable to bear the costs of a sick or injured seafarer from the time at which that seafarer can claim medical benefits under a scheme of compulsory sickness insurance, compulsory accident insurance or workers compensation for accidents. So, there are certain other guidelines also which are mentioned as far as seafarers financial security contractual claim is concerned. Now, regulation 4.3 talks about health and safety protection and accident prevention. The purpose is to ensure that seafarers' work environment on board ships promotes occupational safety and health. Each member shall ensure that seafarers on ship that fly its flag are provided with occupational health protection and live, work and train on board ship in a safe and hygienic environment. Each member shall develop and promulgate national guidelines for the management of occupational safety and health on board ships that fly its flag, after consultation with representative ship owners and seafarers organizations and taking into account applicable codes, guidelines and standards recommended by international organizations, national administrations and maritime industry. Now, in order to fulfill this particular purpose, we have certain standards and then guidelines. Obviously, standards being the mandatory ones, let us look at the important standard that the national or the member state is to comply with. Health and safety protection and accident prevention. The laws and regulations and other measures to be adopted in accordance with regulation 4.3 para 3 shall include the following subjects: the adoption and effective implementation and promotion of occupational safety and health policies and programs on ships that fly the member's flag, including risk evaluation as well as training and instruction of seafarers. Reasonable precautions to prevent occupational accidents, injuries and diseases on board ship, including measures to reduce and prevent the risk of exposure to harmful levels of ambient factors and chemicals, as well as the risk of injury or disease that may arise from the use of equipment and machinery on board. On-board programs for the prevention of occupational accidents, injuries and disease, and for continuous improvement in occupational safety and health protection, involving seafarers representatives and all other persons concerned in their implementation, taking account of preventive measures including engineering and design control, substitution of processes and procedures for collective individual tasks, and the use of personal protective equipments. Requirements for inspecting, reporting and correcting unsafe conditions, and for investigating and reporting on-board occupational accidents. There are other standards also which must be taken into account as far as occupational accidents, injuries and diseases are concerned. There are certain guidelines with respect to health and safety protection and accident preventions, which are largely in relation to the structure of the ship or the certain equipments being present on the ship are concerned. So, let us have a general look as far as the guideline 4.3 is concerned, wherein it says that the competent authority should ensure that the national guidelines for the management of occupational safety and health address the following matters in particular: general and basic provisions, the structural features of the ship including means of access and asbestos related risk, machinery, effects of extremely low and high temperature, effects of noise in workplace, effects of vibration, effects of ambient factors, special safety measures, loading and unloading equipment, fire prevention, firefighting, dangerous cargo, etc. are the necessary areas where we need to look at as far as the health guidelines are concerned. Now, these are not mandatory, but yes, slowly the states, member states can implement with the passage of time as far as their compliance is concerned. These guidelines can be made part of the national laws in order to increase the domain and area of labor rights as far as seafarers are concerned. There are certain other guidelines also with respect to welfare facilities, services in ports, welfare boards, financing of welfare facilities, seafarers in foreign port, dissemination of information facilitation measures. And these guidelines play a significant role as far as expansion of rights of seafarers are concerned and the duties of seafarers. Cumulatively, all of which will make seafaring much more accessible, seafaring much more a lucrative job, and will free the seafarers from the subjugation of the employer as we had seen it earlier. So, in conclusion, we can say that the maritime industry has always been internationally acclaimed. Now, it is turned global. Maritime transport has been at the forefront of globalism, with the consequent possibilities and intimidations for both capital and the working class. The industry is molded in a way that allows those who opt to play roulette with the seafarers and passengers' lives, property and the environment. The ILO's Consolidated Maritime Labour Convention 2006 is without a shred of doubt the best convention the maritime sector has perceived in the history of shipping for the welfare of seafarers. The MLC is aptly being recognized as the fourth pillar of the shipping industry after the SOLAS, STCW, amended MARPOL conventions are concerned. To conclude, MLC 2006 is a well composed convention covering all the requirements of seafarers, though it has favored the ratifying countries by not providing stringent guidelines for implementation. With this, I conclude the lecture and the details on seafarers' rights and responsibilities. I thank you for your patient listening. Namaskar.